I'm grateful to be here. I'm grateful to be able to work on these issues and to be able to discuss with you today the innovative legal solutions to combat the rise of sexual exploitation. So I'm really just going to be talking to you about what projects we have been working on at NCOSE. The Law Center started last year through a couple of grants and opportunities that we were given. Our CEO and president, Patrick Truman, has been involved in prosecuting pornography since the 1980s, and he saw that there was this great need for a legal presence in the pornographic fight, and especially to take on all of these issues. We're not just involved in pornography issues, but a variety of issues, because as we've been talking about at this conference, they're all connected. And so at NCOSE, we work on a very national policy base. So we don't really have the opportunity to be in court every day. I object and things like that. But we have an opportunity to have a presence. We support a lot of things. We try and get our name into issues. So I'll just be kind of highlighting some of the issues that we've been working on and how those have played out. So first, you may be aware that Utah passed the resolution to recognize pornography as a public health crisis just this last year in March. And our director of the Law Center, Danny Bianculli, wrote that resolution. Back last year, some concerned citizens in Utah contacted our office, and they knew that we had Law Center, they knew that we were involved in these policy issues, and they said, we really want to get something happening. And we decided to go with a resolution. So what the resolution is it is pretty much peer-reviewed information. It is a page and a half of all the issues, and then there are, I think, 6 pages of endnotes, just highlighting all the peer-reviewed articles. And the Utah State Legislature passed it unanimously, and it was wonderful and beautiful. And it has changed the discourse on pornography. We are trying to take it from not just a moral issue, which people just assume means religion, to a public health crisis, that this is an issue that it's bigger than one person can handle on their own. It is a public health crisis. And we've been trying to formulate it similar to the view of cigarettes in the early 90s, that it was a public health crisis, that the tobacco industry had taken over so many ads and different things like that, and they were influencing women and children and men that cigarettes was cool. And the same thing is happening. The porn industry is taking over and influencing women, children, and men, and saying that porn is cool, but it is damaging and it is bad. And as you've been able to see from the conference this year, that there's so much literature that shows that it is bad, that it is connected to all of these different issues. And so to be able to have this pass in Utah has been monumental. And the health crisis resolution, it doesn't have teeth. Like, it doesn't make pornography illegal. There are already obscenity laws and different issues within each individual state. There are obscenity laws, some federal obscenity laws, saying that it is illegal to sell or distribute obscene material across state lines and different things like that. But what this resolution does is it provides like structure, and it's something that we can all cite to and say, look, this is bad, and all these peer-reviewed articles say that it's bad, and it puts a lot of emphasis, and it really it's brought a lot of attention to the media. And then also the RNC recently recognized it as well as a public health crisis, and we're working with a lot of other states currently to get these things passed. So it's very positive. We are very, very, very excited about this. And we feel that with this, we've been able to have just so many more doors open up, so many more people are willing to talk about it and to realize it's not just a moral issue, it's not just a religious issue, this is a society issue. So this has been great. The next one that I got involved in was, you may have seen one of the most recent Calvin Klein ads that came out. They came out with this erotic ad section, I don't even know what to call it. And this photo is a photo of a very young looking girl, and we've cropped it because what it was is it was a picture from the floor up of her straddling the photographer, and the photo showed up her dress. And it's terrible. It shows her underwear, and you know, it's so horrific. This is sexual harassment. This happens all the time in real life, and to have an ad like this posted out like in you know, in Times Square in New York, that makes, for lack of a better word, perverted men think that it's okay, and it normalizes it. And so we started, within all of NCOSE, we started an ad campaign saying, I cut Calvin, that Calvin Klein it's not okay, and that we're going to cut Calvin Klein out of our lives. We're not going to purchase Calvin Klein products at all because they're promoting sexual harassment. And then in the law center, what we did is we realized in looking through these things, a lot of states do not make this sexual harassment illegal. And there are voyeurism statutes which prohibit like peeping Tom issues, looking at individuals when they're in a private place, like in a backroom. But there's been this huge gap in women being in a public sphere, and some judges have said that women do not have a reasonable expectation of privacy up their dress in a public sphere. Yes, and now with those cases, it was very, very specific. Apparently the women were, you know, not exposing themselves, but they're like in a dress, but sitting kind of with their legs spread a little bit. And so the photos that were taken, like anybody could see, but it's still horrible. Like to walk around, this case specifically was in Washington, D.C., to know that I can be standing on the metro and a man can surreptitiously take a photo of me up my dress. I would punch him in the face, take his phone and throw it, and then I would be held liable for like battery because I attacked him because I was being sexually assaulted and harassed, but it's not verbatim illegal. So we went through and we developed a database looking at all of those statutes and the corresponding court cases that determined where these statutes are, because a lot of the statutes are older statutes. They don't say verbatim, this is illegal. Fortunately, in the state of Virginia, they say it's very, very blatant. You cannot take a picture of a woman up her skirt. You cannot take pictures of clothed genitalia or private places, even in public spheres. I think it's the state of Wisconsin. They had a case like this. Their statute was a little bit vague, and it just said, like, the idea is this reasonable expectation of privacy. Statute says, you know, when a woman has a reasonable expectation of privacy, and so many other courts said, well, in public, you don't have a reasonable expectation of privacy. But in Wisconsin, they said, if we're looking at the place where a reasonable expectation of privacy should be, they said it is not like in a public sphere, but it is within the realm of the woman, her personal space. And so they're like my favorite state right now, but I love those judges. Yeah, oh, woohoo, Wisconsin. So, we've been developing these things, and we're trying to contact these different state legislatures to let them know this is an issue. This is a gap in your statutes, and it needs to be fixed. It needs to be solved so that women are not dealing with this sexual harassment in their lives. Yeah.
Is Target using any of these to support their policy?
It's been interesting because a lot of the court cases that I looked up, these issues, this upskirting was occurring in Target and in Walmart. And I can't get into all of those other issues, but to me that would say that should provide reasons why there should be extra protections in backrooms and things for women because this is occurring too frequently.
Are your databases online that we can access?
Not yet. We will be getting those online. We've been bombarded with a lot of legal issues lately, so hopefully within this next few months we'll be able to get that up online. That's a great question. The next one that we've been working on is massage parlor ordinances. I grew up in Utah, got plenty of nice athletic massages. I'm an athlete. So I had no idea that this was actually a thing, that illicit massages were occurring, that you could go get a massage and you would receive prostituted services as well. But in Virginia, in Fairfax County, which is one of the most wealthiest counties in the United States, this is a huge issue. They have found over 90 illicit massage parlors where generally Asian women or other ethnic women are seemingly being trafficked and brought into these massage parlors. They stay there for who knows what amount of time, and they have to provide prostituted services for these men. And unfortunately, the county of Fairfax has not addressed this. They don't think it's a problem. They don't believe that these issues are occurring, or they don't believe that that these illicit massages are really bad for these women. It's disgusting. It's really sad. And so we are in the process of looking through various massage ordinances. There are a lot of different cities, counties, and areas that have tried to regulate this. And so we are in the process of trying to develop a really good, solid massage parlor ordinance where, one, legitimate massage therapists and groups can function without a lot of hoops to jump through, but where we have enough hoops for these illicit groups so that they cannot function. It has to do with a lot of trafficking, a lot of organized crime. There are a lot of issues with it that all come together, and so this is one issue that we're trying to work on. It's been kind of sidelined because of another issue that we're working on, but I'll get to that in a moment. We also have been working on a sexually oriented businesses manual. This is, if any of you were able to listen to or hear from Scott Burkholt, this is a lot of what he does. He goes into these cities and towns and communities and he helps them develop a solid sexually oriented business ordinance and then how to fight against it. Several years ago, the group ADF created a manual that can be used by smaller communities that can't quite afford an expensive attorney to be able to start to develop their own ordinances themselves. However, it hasn't been updated for like 10, 20 years, and the things have changed. And so we are working on trying to update that and really trying to get behind these issues and really understand the case law behind it so that we can provide services for these smaller communities. We don't want to compete with Scott, but we want to work together and be able to really provide opportunities so that these sexually oriented businesses know that they are not welcome. And you can't fully get rid of them. Like, you can't say no sexually oriented business is allowed. That's against the First Amendment. However, you can heavily regulate them. And as Scott said, you can, file injunctions and different things when they are not behaving properly, and you can shut them down. So we want to be involved in this as well, and we've been working on it. We've been working with a lot of we had a legal intern this last summer who was great and really did a great job on a lot of research, but we still have a long ways to go. It's a very, very thick manual, so we're working on it. But hopefully, we hope to roll this out within the next year of being able to provide services for this. The next one is, this is where I'll probably spend most of my time. I don't have a ton of time, but we are currently working on an amicus brief for the Ninth Circuit, and I'm calling it the S-Plurp amicus brief. S-Plurp sounds like a ridiculous name, and it is, and the group behind it is even more ridiculous. It is a pro-prostitution group in the state of California that is suing the state of California, saying that their anti-prostitution laws are unconstitutional. And the Attorney General in the state of California has done a great job in defending these laws. They filed for a dismissal in the district court and were awarded a dismissal, but S-Plurp, being the seedy group that they are, they filed for an appeal to the Ninth Circuit. And if anyone is familiar with the Ninth Circuit, it is one of the most liberal circuits in the United States. It covers over 20% of the nation's population. It covers Alaska, Hawaii, California, Washington, Oregon, Nevada, Arizona, Idaho, and Montana. I think that's all. But that's 9 states. 9 states out of the 50 are covered by one circuit. And this circuit has a lot of power. And the reason why there's so many states is because California is so big. So you can't have just like one circuit over California. So they added a bunch of circuits, or a bunch of states to it, but now it's just this giant conglomeration, and it's had a huge effect on, like, the Ninth Circuit has a huge effect on where we go with the nation. There are a lot of cases in the past that the Ninth Circuit has heard. They've been overturned at times, but they kind of like to start the conversation. They're that friend that just like won't shut up sometimes. But then after a couple of weeks or months or whatever, like, other people are like, yeah, they're right. Like, I'm not going to get into politics. Okay, I won't do that. So it's a problem. And the Ninth Circuit, they're very liberal, so we have no idea what they're going to do on this case. So we have decided that it is important for us to step in and to make our argument as well. So we're writing an amicus brief. Amicus is Latin for friend, and it means friend of the court. So like in French, you have ami, that means friend, or like in Spanish, amigo, it's all Latin based. So we are writing to the Ninth Circuit as a friend of the court, and we are letting them know our perspective. And it's our perspective which has to be slightly different from the Attorney General's perspective, because they don't want to read the same argument over and over and over again. And so what S-Plurp has argued in their case is that they argue that based on a case in 2000 called Lawrence v. Texas, based on that case, they believe that the Supreme Court says that sex should be like free reign, pretty much. And their argument is that two consenting adults in the privacy of wherever they choose to be should be allowed to participate in sexual activities, whether for compensation or not. And it's that for compensation that is a problem, because the Lawrence v. Texas case The Supreme Court said that two consenting adults in the privacy of their own home should be able to do what they want without, the state's interference, which makes sense. You should, okay. But it's this compensation issue that is a problem. And our argument is actually that their entire argument when it comes to prostitution is false. First, consent. We've just heard from Taina Bienami, who is fantastic and has been working against prostitution issues for such a long time, but she hinted about this issue of consent, that so many prostituted persons have become involved in prostitution from a lot of underlying reasons, that although there is this very, 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 very small percentage of people who believe that it's like this sexual revolution to just go and prostitute themselves, they're like the tiniest percentage in the world, and the whole rest of this group have either been sexually assaulted or raped or taken advantage of when they were children. They were prostituted, sex trafficked when they were children. They were involved in poverty or like drug addiction and all these different things, that it's not consent. It's not. It cannot be viewed as consent. I'm gonna put my phone. Maybe it's up there. Sorry, hold on. Thank you. I had a quote that I found from a writer. Kat Benyard made an argument against the normalization of prostitution, and what she said has really stuck with me and really affected me. And it's about consent and payment. She says, if, while having sex with someone, you feel repulsed by touching them, you are afraid of what they might do, degraded and humiliated by the sexual acts, hurt by the hateful words they're whispering in your ear, sore because he's the fifth man you've had sex with today, exhausted from it all, traumatized and abused. The fact that you'll get a bit of cash at the end does not change anything. And this idea of disgust, terror, and pain, that is not what sex should be. Those are the feelings of rape. And so by their argument that people should be able to consent to this is ridiculous, and it's incorrect. So that's one part of the argument that we're making. The other part, that they said that this is a private act between two adults is also false, because by commodifying sexual acts, you are automatically throwing this act into the stream of commerce, into the public sphere, and there will be advertisements and all different sort of things that take away the privacy of this act. It is no longer private in that sense, and so because of those things, we are arguing that the state of California has a right to regulate and prohibit prostitution. And with this argument that S-Corp is making, if the Ninth Circuit decides to agree with it, then their idea that the commodification of sexual acts should be outside of the state's ability to control would make it so that sexually oriented businesses would be blanketly allowed, and that these illicit massage parlors would be blanketly allowed, and all these things, just because it's quote-unquote consent, would automatically be allowed. And so I was talking with one of my friends as I was preparing for this and writing this and saying, I feel like it is like me standing in front of this huge wave of the possibility of sexual anarchy, and the hope that what we're doing can really, really have an effect, and hopefully the Ninth Circuit will be willing to listen and will be willing to accept these arguments, because otherwise, we're in for a lot of trouble. And if the Ninth Circuit accepts that argument, then these little groups will pop up in each and every other state within the Ninth Circuit, these 9 other states. and they will be able to make the same argument, and the Ninth Circuit will have to follow its own precedents. And so really, prostitution would be allowed in all of these states, and we cannot allow that to occur. And so at the National Center on Sexual Exploitation, we are at the battlefront. We are fighting as hard as we can and doing everything that we can to prevent these things from occurring. And that's pretty much the presentation that I'm offering today. We need all the help that we can get, though, and we are definitely accepting groups who are involved in this to be willing to sign on to our amicus brief as well. So I don't know if Lisa contacted you yet, but we are going to about signing on to this for Shared Hope and a couple other different groups. Yeah, this is what we're working on. This is my contact information. I have about like 2 minutes for any questions, if anyone has anything for me.
Thank you for your work.
Thank you.
Absolutely, that's brilliant.
Thank you. Yeah, I love what I do. I feel like I am fighting evil every day. And so
Absolutely.
when I first started, I had a friend ask me like, oh, isn't that like really difficult? Like you must be really stressed out. I was like, no, like I feel like a superhero. I love it. I love what I do because I am making an impact and I have this opportunity. So I'm grateful for it, and it's through the help of others that we can participate in this. Yeah.
I'm an attorney, but I'm a corporate attorney. But for attorneys, how could we help? Is there anything that people like us could do for maybe helping with some research? We realize we're not experts in this, but we do understand law and how to read that.
Yeah. Yeah, absolutely. We are trying to actually develop also a database of attorneys that are concerned in these matters, so that when there are issues like this, that we can reach out and say, we need research, we need help, we need, someone within this state who will be willing to be the lead attorney, and we can come in and provide lots and lots of assistance and things like that. So definitely give me your contact information, because that would be great. We're in the process of getting all these things developed. We're so new that we're just doing everything that we can now, but we can definitely use all the help that we can get.
Do you also work with ACLJ at all?
Good question.
Because they do things, not exactly this, but maybe this.
Yeah, they definitely are involved in a lot of cases, a lot of issues, and we work with them. We work with ADF a lot, and they have in fact helped supply us. We emailed them and said, hey, we're working on this brief. We need some extra help researching, and they sent out an email to a bunch of their attorneys. We got some help back. So yeah, and there's a lot of different groups that we've emailed, and that we're starting to, as I'm finishing up this brief, it's due the beginning of November. So we've been preparing for this, and the brief has been crazy and great. Yeah, we've been in contact with these groups, and we'll be reaching out and saying, like, who wants to sign on, who wants to have a voice in this. They won't really have a lot of chance to really like edit what we've been writing because we've been working on it for so long, but at least to put their stamp on it and say, yep, we agree, to really show, the Ninth Circuit that there is a lot of support behind this is exactly what we need.